Please be seated.
Good afternoon. We now move to the third case on today's docket, Smith versus the State of Florida.
Good afternoon, Mr. Chief Justice, and may it please the Court. My name is Rachel Roebuck from CCRC Middle, along with my co-counsel Eric Pinkard.
Could you speak up a little bit?
Yes, we represent Mr. Delmer Smith. Does that help? Okay. I want to begin today by addressing the ineffective assistance of counsel claims as to the motions to suppress at the trial, as to both the duffel bag and the plastic bag. And then, if time permits me to, also address the mitigation claim. I'm going to begin by discussing third-party consent. Martha Tejeda, who was Mr. Smith's paramour at the time of this trial, or at the time of his pretrial detention, did not have authority to consent to the search and the seizure of his bags. The trial court below erred when they found that Mr. Smith abdicated control of his items that originated in a storage unit.
Didn't she have apparent authority?
I think the difference between, I don't think apparent authority applies in this case, and I'll tell you why. I think the difference between actual authority and apparent authority is that a mistake was made. So the standard is the same. The standard is mutual use by persons with joint or common access for most purposes.
They're not quite, the mistake was made. The difference is, one is there's a subjective, you have the authority. The other is, to the outside world, you objectively have authority, even though you may not. That's the difference, as I understand it.
Correct.
Okay.
So, but there were no mistakes made, and there were no misgivings in this place that police had. Everything that you and I know now, the police knew on September 11th, 2009.
Here's what the police knew. That they went to Ms. Tejada's house, that Ms. Tejada had in her house a duffel bag, and had the car of Mr. Smith, and
Yes.
inside the car, which she had the keys to at the time, and she gave over the keys because they knew that it had the Mickey Mouse thing on the Mickey Mouse keychain on the keys at the time, and had the bag inside the car, that they gave over those items to police. That's what the police knew, right?
Yes, the police knew that. The police also knew, because they listened to the jail phone calls, the objective belief of Mr. Smith that the purpose of telling her to move this property was that no one would find it. So they did know, but they didn't mistake that it was her property.
But what he said was, I need you to go to my things and get this. I need you to go
Yes.
get my keys and take my car
Yes.
and hide these things, except for some of it I need you to throw out, right?
Well, what
The
specific thing are
clothes.
you saying?
The clothes.
So when you go to the specific page of the transcript where he's talking about the clothes,
Yes.
there are several points where it says unintelligible. And during that conversation with Mr. Tejeda, Mr. Smith is talking about his ex-girlfriend, whose name is Michelle, who threw out a lot of his belongings. And so when he's referring to the clothes, he's saying the clothes that are in my storage were the only ones that were not thrown away. They were what were salvageable. So I don't think he's instructing her to throw the clothes away.
If the police know that someone else has been given access to property, that property is now within their exclusive, that other person's exclusive possession, because he's in jail, he can't have possession of them,
Right.
that they've been taken away from a hiding place to them, and that she now has complete and access to them, and that he specifically asks her to go within the duffel bag, to enter into the duffel bag. How is that not at least apparent or joint possession, or at least apparent authority to access those things? Just having a hard time understanding that.
Okay. So joint access, even if whether or not you have joint access or the potential for joint access, does not mean that you're mutually using the property. So that's the reason that we cite cases.
Isn't it common authority over the property?
Well, it's mutual use by persons who have common or joint access. That's what authority is defined as. So our argument in the briefs was that since she is not mutually using this property, take the state's case that they cite, Frazier v. Cupp, where the defendant and his cousin are sharing a gym bag, and the cousin brings a gym bag to police and says, I think there's something in here that you might want to see.
Isn't this how authority's been defined, at least by some courts in the state? Authority to consent to search arises from mutual use, as you've said,
Yes.
by persons generally having joint access, common authority over, or, so it's an or, meaning there's three of them, other sufficient relationship to the premises or effects to be inspected. Isn't there a sufficient relationship to the effects to be inspected? That is, I have the keys to the car, I drove the car here, I am the only one that has, at this point, access to the car. I have my own house with that duffel bag in it where I've been told to go inside. Isn't that sufficient relationship to the premises?
So two responses to that. The first is she certainly had authority to consent to the search of her home because it was hers and she lived there. What that does not extend to is the authority to consent to the search of containers or items within her home that do not belong to her. And although she did have the keys, and the Minnie Mouse keychain, by the way, was in the lockbox. This was a different set of keys. So she did have the keys, but she didn't have the keys, like in most authority cases, just by virtue of their closeness or their intimacy, or because they had commingled or shared property.
So let's say, for example, that I knock over a bank, and I take proceeds from that bank and put it in a duffel bag and the
Yes.
garbage, and I put my clothes in the garbage bag because I don't want those clothes with my DNA on it to be discovered.
I'm sorry, you put...
My clothes in a garbage bag
Okay.
because I don't want the DNA to be discovered. And I
Okay.
take that garbage bag and that duffel bag with my knocked over proceeds to my girlfriend's house, and I say, girlfriend, can you please hold on to these things for me so that they are not discovered by the police, and then I leave. Does my girlfriend not have some authority over those items in which I dropped at her house?
I think if the intent is clear, that the purpose for her having possession as far as they're being under her roof of that property was to store them, then I think that you do maintain a reasonable expectation of privacy in those items.
Well, that's not really the question. I might, but that doesn't mean that she doesn't also have some expectation of privacy and control and authority over those items for which she cannot do. So those are two separate and not mutually exclusive things. I still maintain a Fourth Amendment right. In other words, I tend to agree with you that they're not abandoned, those items.
Okay.
But that's separate and apart from whether they are jointly held for purposes of, do I have the authority to consent, right?
Those are two separate things, I would agree with you.
Right, and isn't there at least sufficient indicia here for the latter, even though if not necessarily for the former, the latter being
thank you.
joint control?
There is sufficient indicia of joint of control and access to the property, but there isn't for mutual use. That's my point. So, for instance, the state cites the case Heen from this court, or Hain, in 2017, which is very similar to the factual pattern of this case, except for a very important distinction. The defendant is accused of a murder. He goes to his friend's house, basically says, I'm leaving this, I just killed 2 people. I'm leaving this gun in your attic. And the reason that this court said that that friend did not, or did rather, have actual authority to hand over those items and the expectation of privacy was gone was because that friend told the defendant in Heen, you need to get that out of my house. I don't want that in my house at all. So there was no reasonable expectation that what you're leaving in this house would have remained private in any way, shape, or form. That's very different than what we have here on the phone calls, where they're specifically talking about, keep this for me, keep this until I get out. Yes, I'll keep it for you. I have no problem doing that.
Can I talk to you about prejudice here?
Yes.
So let's say I agree with you. At least as to some of the items, wasn't there also testimony in the evidence that your client was connected to those items? For example, didn't Ms. Quinones testify that at least some of the stolen items that were identified, that she had been given them or she saw the defendant with those items?
Are you talking about the encyclopedia?
That's one of them.
Okay.
And wasn't there a watch also?
Yes.
Okay.
The watch was inside the lockbox. That's another. Well,
Right.
the watch, there was a matching set of
That's
watches.
right, the matching set.
So, with respect to the medical encyclopedia, I do agree that there is testimony in the trial record that even perhaps if you suppress the physical book, would have still been allowed. But what would not have happened had you not had the physical book and evidence was the Briles family would not have been able to say, that is the book that's been in our house for years. It would have just been like they both have medical encyclopedias.
What about Mr. Sellers? And I apologize if I'm pronouncing his name incorrectly. He also testified that he pawned or went to the pawn shop for some of the stolen items that were there, correct?
Yes, he did.
So given that Ms. Quinones identifies them as some of the stolen items and Mr. Sellers identifies the defendant with some of the stolen items, wasn't the testimony that it was found in this duffel bag in Ms. Tejada's house and in the garbage bag not really all that relevant, given that there was already significant connection to there?
So I want to
In other words, such that it would have changed the outcome in this case?
I do think that it would have changed the outcome in this case, and I'll explain why. Mr. Sellers was the alternative suspect. The defense strategy at trial was that he was the real killer. And although he identified Mr. Smith as having possession of the necklace, for instance, he was the one who pawned it. And although he testified that he'd seen Mr. Smith with the medical encyclopedia, he also tried to lie and say that he had never touched it, and he was impeached. And he's also connected
to... Your
to...
client's fingerprints were found on it, right?
Yes,
right.
They were. He's also connected to access to this storage unit that we're talking about, Northport Storage. He had been there before. He knew how to get in. He had been there with Mr. Smith. And he also has connections to some of the items that are in the plastic bag, the tools, the model airplane. So he's got all these connections with...
And the jury still would have heard the phone calls, right? Those would have come into evidence?
If the motion to suppress was granted,
Sure.
I'm not sure what a lot of the relevance would be at that point.
Hey, I want you to hide something for me. Please go and get stuff for me.
Well, actually, the edits of those calls is very unfortunate because what Mr. Smith is actually saying to her in the unedited versions is he's needing her to get a BB gun out of his storage unit. So what it sounded like at trial
It's
was...
very, very important that you, Ms. Tejada, get that bag out of there.
I understand. That's
Listen,
where the
take
rifle...
all the bags out of the storage unit, the big bag. You got to open it. You got to get it yourself.
That's where the BB gun was. So
Right.
what he's saying is, and it turns in it, the way it's edited, because it was motion and limb out, because this was not a gun case, but the way it's edited makes it seem like I need you to go get this stolen property, when in actuality that's not what he was saying. I want to move on, if I can, if there's no other questions about consent, briefly to the inventory search issue. So the state claims that this is an inventory search. It is not.
But do we not need to get there? Just sorry to interrupt, but we don't need to get there if we find actual or apparent authority for the search. In other words, we don't need to get to the inventories.
There wouldn't need to be that safety.
Right, that was an alternative rationale of the court, that it was an inventory search, and based on that, they obtained the search warrant, right?
Correct.
Okay.
Yes. However, if you don't get there, there's plenty of evidence of pretext here, which would negate that this is an actual inventory search. Detective Delmer at the evidentiary hearings admitted that the reason that they went to acquire this property was evidence collection. It was not property that traditionally, like, police are burdened with when they arrest someone and have to inventory and have to catalog.
Wasn't there also contrary evidence, though, that it was, in fact, a inventory search, and that they did otherwise follow, other than taking the pictures, department policy?
There was evidence that they took photographs. There was not evidence that they took photographs exactly per department policy because the photographs were not in every stage of opening.
But there were officers who did state that this was an inventory search, contrary to what the other officer stated, correct?
Well, yes, but perhaps, I mean, if you look at the actual, for the bag that originated in the car, for instance, if you look at the property receipt, the evidence box is checked. Instead of safekeeping or found or any of the other options, it went to forensics the next day. So even after they're collecting these items from this house, they're treating it much more like evidence than they are property that they're just safekeeping.
And the trial court, the post-conviction court, heard this contrary evidence, some that you're talking about,
Yes.
the other evidence, and made a finding that it was an inventory search, right?
Certainly.
How are we to undo that finding? In other words, the trial court hears contrary evidence and then makes a finding that this was, in fact, an inventory search. It was not pretextual. How do we rule contrary to that?
because there's so much evidence that it was actual pretext. So the inquiry when you're talking about whether an inventory search is legal is, like I said, the motivation for acquiring the property. If you have an evidentiary motive for acquiring the property, you are not inventorying it. I would like to move on to the mitigation issue. Mr. Smith received ineffective assistance of counsel at the penalty phase of his death penalty trial. Had counsel not been ineffective, Mr. Smith's jury would have heard from Janet and Patricia, his sisters, that he suffered extreme, severe physical abuse from the age of 2 until he left the house at 17 at the hands of their father and mother.
Did counsel, and you're in your rebuttal time, so I don't want to intrude on that, but.
I would like to intrude on it myself if I could,
Okay.
and then I'll use the remainder.
Can I ask a question or two?
Yes,
Didn't
of course.
didn't counsel actually have the mitigation specialist reach out to all 3 of the sisters or the 2 sisters who testified?
So Colleen Quinn, the 2 sisters, they call her a woman, they don't remember her name, but they say a woman contacted me in 2011, 2012. Patricia says, I told her everything I'm telling you now.
But there was contrary evidence to that. Both the attorney and the investigator stated that the sisters never called back or returned their phone calls and were uncooperative after your client heard about it, got upset, and instructed them not to reach out to family, right?
So 2 responses. Janet and Patricia were both asked, were you in contact at all with your brother during the trial phase or the penalty phase? And they said no. Also, Mr. Brunvin admitted that he didn't personally contact
the question
anyone.
was that the testimony from the investigator and the attorney?
The attorney testified that his suspicion was, because when they went to visit Mr. Smith and told him, we contacted your sister, he was angry. And after that, no further cooperation was able to be had. But Mr. Brunvin said that he didn't personally contact anyone. So it's Colleen Quinn.
Didn't counsel testify, though, that as a matter of strategy, that he didn't want to alienate his client, and it took a lot of coaxing to finally get your client to sign off and do a testing and do psychological testing and neuro testing and all of those things. And they didn't want to antagonize him more and shut him down more because he had been uncooperative to that point by contacting the sisters, right?
Yes. However, at the sort of quasi-Nelson hearings that we have where they air their grievances with each other, Mr. Brunvin clearly states that if he's not going to wholesale waive mitigation, I'm the driver of this car and I decide what is in his best interest and I decide what witnesses, not him, we're going to present. And also, even if you find that the deficiency didn't affect the jury, so if you find that Mr. Brunvin was thwarted sufficiently so that the jury just didn't have time to get this sort of information, Mr. Brunvin admitted that direction to not talk to my family was lifted right before the trial started, and there were 8 months in between the penalty phase and the Spencer hearing where he could have called Janet and Patricia, and he said, I made no attempt to do that.
Counsel, you have now used more than half of your rebuttal time. You may continue, but you're consuming it.
Would you like to ask a question?
Why don't I let you keep your rebuttal time?
All right, thank you. I appreciate it.
May it please the Court, Timothy Freeland here on behalf of the state of Florida. Dealing first with the suppression issue, and the duffel bag and the garbage bag, I think it's clear that there was apparent authority. We get that from the jail calls, where the defendant is speaking to Ms. Tejeda and telling her what it is that he wants done with these bags, tells her, I want you to do these things. I mean, that gives her the authority to go in and go through all of the bags. I think it's clear that we have apparent authority based upon that information. But as Judge Luck, you correctly noticed that there's an alternative basis that the trial court, the post-conviction court, used in finding that counsel was not ineffective here, and that is that this was a valid inventory search. There was testimony from Detective Delmer who explained the Sarasota County Sheriff's Office standard procedures for conducting an inventory search. They do not take property in where they're, if it's, as long as it's not locked, if it's a bag which is enclosed, they're going to do an inventory of it because they don't want dangerous items in their property room. And that's the basis.
Because they have no idea what's in the duffel bag, right?
Right, and as my counsel pointed out, there apparently was a firearm in the duffel bag, so there was good reason for them to want to open up the duffel bag and look through it. This is not a search. It is merely for the safety of law enforcement and their property room. Now, inside the duffel bag, certainly they found a lockbox. They didn't open that lockbox until they got a search warrant to open that lockbox.
In other words, does that indicate intent that this was not done for evidence search, but in fact was done for purposes of an inventory search?
Correct.
Because otherwise, we just jam open the lock.
Why wait? And why not just open up the lockbox immediately if all we're doing is, if that's the intent? So I think that clarifies and shows the validity of the lower court's ruling in this aspect. And we have to be able to show, I mean, in order to find that counsel was ineffective, the defense has to be able to show that no attorney would have done what this attorney did, no reasonable attorney. And I don't think that they've established that at all. And secondly, in terms of prejudice, on the prejudice prong, we have, even if all of that evidence was excluded, we have a mountain of other evidence that links this defendant to this homicide. We have the Miss Quinones, the watch that the Briles family was able to identify as having belonged to the victim that she was in fact wearing when she was...
It's not just to the homicide itself, it's to the actual same property. I mean, you have testimony that links him to the exact property that was ultimately found in Ms. Tejada's house, right?
Yes.
The watch and the keychain and the
diamond necklace.
And the necklace and the encyclopedia.
And the encyclopedia, yes. All of those things link him. So even if this court, and I'm not expecting this court to find that way, but if this court were to exclude everything that was in the duffel bag, there's still ample evidence linking him. Not only do we have the physical evidence that was, I mean, the jewelry and the physical items that were collected, we also have, of course, the cell phone testimony, which shows the cell tower testimony, forgive me, which shows the defendant who lives in Northport driving up to the vicinity of where the victim lived. It's approximately a 50-mile ride, if you look at the map, from where he lives in Northport up to Terracea, where the homicide occurred. That cell tower information places him in the vicinity of Tower 304 at about the time that the homicide occurred, at 3:38 or 3:45. So there's other evidence that links him to this case, and the inventory search, regardless of how this court rules on the inventory search aspect of this case, there is no way that this court could find that this attorney was ineffective for handling this case in the way that he did. If we can turn now to the mitigation issue, first and foremost, the most important thing to pay attention to here is that the reason why counsel was unable to obtain more information from the defendant's family is the defendant himself obstructed that information. The defendant said, "I don't want you to get my family involved." And when he did go over his client's instructions and spoke to one of the sisters, the defendant became very upset with him. And it was important, of course, for him to try to maintain some kind of a working relationship with his client, because they're...
Do you agree, though, as a matter of federal habeas law or federal ineffective assistance of counsel law, that the client's wishes are not dispositive with regard to this unless there is a waiver?
They're not necessarily. Yeah, they're not necessarily. What happens, though...
I'm sorry, I don't know if I understood your answer. You agree with me that as a matter of federal habeas law, counsel still has an independent obligation to investigate mitigation,
yes.
Even if the client says, "I don't want you to do that."
Yes, absolutely. That is what federal habeas law says, and that is what counsel did in this case, because if you look at the mitigation that counsel obtained, some of it he obtained over his client's express wishes. Don't do this.
There's no doubt that counsel, at least appears to me, to have done a really stellar job here in presenting a case for his client. But with regard to the sisters, is it constitutionally enough to just call one time, get no response back, and then listen to your client to say, "Don't do it again"?
It depends on the circumstances.
Which seems to be what happened here.
Well, he did contact them, and in fact, Dr. Eisenstein, who was their mitigation expert, their psychologist, did in fact speak to one of the sisters. And so he got information from the sisters, one of the sisters, that he was able to use to present a wonderful mitigation case for the defense. But what is the counsel supposed to do when he makes that first step, and then all subsequent attempts are rebuffed by the entire family. They were unable to communicate with anybody from the family.
All subsequent indicates that there was, you called 5 times, you went and knocked on a door, and you got a slam door. You're required to shake the trees, you're not required to rip the leaves off of it. I get that.
Yes.
But what I don't understand, or what I am concerned about, is the evidence seems to suggest we called once, we got sort of a hang up or no call back, and I told my client got upset, and that was it. Is the evidence that there was more than what I just described?
With regard to how many times they called, I'm not exactly certain that there was just one call. I think what the attorney testified to was that, I mean, he was not the one who made the calls. It was their mitigation specialist who made the calls. But he said specifically that the one sister we were able to get to communicate with us went from being helpful, willing to communicate, to not returning our phone calls at all. And how many calls they made, the record is not clear whether they made 1, 3, or 5. We don't know.
And the trial court found that the defendant obstructed
Yes.
that effort.
Yes, that's right. But, you know, if we look at it now in terms of prejudice, what additional information was obtained at the post-conviction that was...
Well, let's talk about that. So didn't Dr. Eisenstadt, wasn't he able to testify to abuse suffered by the defendant?
Which he did at the trial.
And in fact, the trial court found as a mitigating factor that he assigned weight to childhood abuse, correct?
Yes.
In other words, the same thing that we're doing was accounted for in the mitigation aggravation weighing, correct?
That is my point. Yes. I mean, the thing that Dr. Eisenstein was able to say is, I went to the defendant's hometown, I saw the house that he grew up in, it was in a bad neighborhood, I saw the place where he was abused, I spoke to the family and determined that yes, the abuse did occur, and it confirmed my diagnosis. It confirmed what I testified to at the trial. The only thing additional that Dr. Eisenstein was able to testify to was that I now believe that he suffered from post-traumatic stress disorder. The lower court found that when looking at this additional mitigation, when you compare it with the really strong aggravator, evidence supporting the aggravators in this case, that little bit of mitigation was just not enough to outweigh the real. I mean, we have heinous, atrocious, and cruel. We have a witness who testified at the trial who was actually one of the defendant's victims. She survived. She came in and testified to the trial court, testified to the jury. I was at home when Delmer Smith broke into my house, 260-pound Delmer Smith, in the safety of my house. He tied me up with electrical cord in a way that if I moved, I was going to be choked. He robbed her, he terrorized her, and this gives us a window into what Mrs. Briles must have suffered. That kind of testimony far outweighs the little bit of mitigation that Dr. Eisenstein was able to secure by speaking to the family. Now, I don't have any other argument. If the court has any questions, no. Thank you.
I want to respond to the allegation that there was a mountain of evidence in this case. There was no DNA in this case, no confession, no prints at the crime scene. This was a circumstantial evidence case based on possession of stolen property.
Can you do the two questions, on the mitigation point, if you can just answer the two questions that I have, which are, was there more than one effort to reach out? Is that the testimony, even accepting the version you don't agree with? And the prejudice aspect he just raised right there. What is there lack of prejudice here, even if Dr. Eisenstadt was able to speak to the sisters?
Okay. So Mr. Brunban said that he didn't do any of the contacting. So then we move on to Colleen Quinn. Colleen Quinn, the last note in the file Mr. Brunban sees as far as contact attempts is before the penalty phase. So even if you think that there is sufficient thwarting to do away with the jury prejudice, there's 8 months in between the jury and the Spencer hearing where counsel makes 0 attempts and directs Colleen Quinn to make 0 attempts at contacting Janet, Patricia, or Alice, who is the only person that he speculates about this, actually being thwarted from contacting Mr. Smith, getting angry about. Now, I'll move on to the prejudice. Dr. Eisenstein was able to diagnose Mr. Smith with PTSD, which is an additional diagnosis, and he was also able to confirm, which is a clinical condition, childhood abuse. And it's not cumulative in any way to what the jury heard or what the judge heard at Spencer hearing. The judge did find, because it was unrebutted, and that's the only reason he found, that there was evidence that Mr. Smith was abused as a child. But what he didn't, he gave it little weight. And I can't imagine a judge or a jury giving little weight to what we now know happened to Mr. Smith in his childhood, which was that his father's favorite time to beat him was when he was just out of the bath, naked, and when he got old enough, that was on a daily basis, and when he got old enough to fight back, which was 8, his father would take him down to the basement and chain him with ropes and extension cords to a pole to effectuate the beatings that way. I think before I run out of time, capital jurors...
Counsel, you have run out of time. You're 37 seconds over. So if you would sum up in another 30 seconds, I appreciate it.
I think what capital juries are looking for when they're faced with a defendant who has murdered an innocent person is, was this person raised or forged? Is there something in their background that if I deleted and took it away so that they didn't have to go through it, am I sure that we would have ended up here anyway? And that is what Mr. Smith's jury was robbed of the opportunity to do. So we're asking you to reverse his conviction because he was convicted with the help of illegally obtained evidence, and we're also alternatively asking you to remand back to Manatee County for a new penalty phase so that the jury can hear about his child abuse. Thank you so much.
Thank you.
We thank you both for your arguments. Now we move to the final case on today's docket, Cannon versus the State of Florida.